All right, it looks like we are ready to proceed. Good morning. Welcome to the April docket of the Kansas Court of Appeals. I am Judge Thomas E. Malone. To my right is Judge Kim Schroeder, and to my left is Judge J.C. Hurst. We are the panel of judges for this morning's hearings. We have 3 cases on the docket this morning. I'll call those cases in the order of the published docket. I'll remind the attorneys that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument this morning. Each side is given 15 minutes for your argument unless it's designated differently on the docket. And I do think we have a couple of those cases. The appellant's attorney should let us know at the beginning of the hearing if you wish to reserve any of your time for rebuttal. After the arguments this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written decision out to you and your clients just as soon as we can. So with that, I'll go ahead and call the first case on the docket this morning. It's from Sedgwick County. It's number 123-714, entitled Margaret A. Spear, formerly Nelson versus Damian Mays. And we have Mr. Michael Whalen here for the appellant. Is that correct?
Yes, Your Honor. Good morning.
We have Mr. Greg Kite for the appellee.
Yes, Your Honor. And again, we seem to have had a little bit of instability with the internet. I apologize for that, beyond our control, but we're very glad to be here with you.
Such as it is, we can hear you very well. Sorry, we can't see you this morning, but we'll just go ahead and proceed with the hearing this way.
Okay.
Mr. Whalen, do you wish to reserve any of your time for rebuttal?
Yes, Your Honor. If I could reserve 5 minutes for rebuttal, please.
That is granted, and you may begin whenever you're ready to proceed.
Thank you. Good morning. Michael Whalen on behalf of the appellant, Damian Mays. I'm going to really be addressing 2 of the main arguments today. First, I want to start off with the argument that this case was initiated as an enforcement of contract. And that was, in fact, a ratification of the agreement which prevented the appellee from later coming back and making a claim of fraud or misrepresentation by fraud. And then the other as to whether or not fraud was actually pled with the necessary particularity in order to sustain the claim. In a later case, the court was concerned with a waiver of the right to rescind in Morse versus Kogel, 162 Can 558. The court there held that if after discovery or knowledge of facts which would entitle a party to a contract to rescind the contract, he treats the contract as binding and leads the other party to believe that the contract is still in effect, he will have waived his right to rescind. And that's from a Kansas Supreme Court case, Stefik versus Witchers, 211 Can 342. And basically, in early 2016, the plaintiff appellee filed a petition against Mr. Mays for enforcement of a contract. And this was based on a contract between the parties for the sale of a pipe organ and a sign, where a $30,000 payment had been made and there was still $9,000 outstanding. Just about 11 months after that initial filing, petitioner then came back and filed a brief new petition, or an amended petition rather, wherein they claimed that Mr. Mays, through fraud, misrepresentation, concealment, and illegality, rendered the parties' hands unclean. And that based on the unclean hands doctrine, they were then requesting that the contract be rescinded and that the parties go back to the state that they were before the agreement was entered into. Now, one of the big issues, and in looking at this is the Kansas Supreme Court has stated on numerous occasions, going back as far as the 1950s, that once a party who discovers the facts necessary to cause them to investigate or consider whether or not fraud has occurred, they must promptly file that claim. In fact, the Kansas Supreme Court stated that the equitable remedy of rescission is open only to the diligent, that the time within which an action for rescission may be commenced is governed by the matter of a plaintiff's diligence rather than by some provision of the statute of limitations, and it must be commenced promptly or it will be demurrable. Now, the facts presented at trial showed that on, I believe it was February 17, 2015, the police had a search warrant for Mr. May's home. They entered, they found a number of items from the Joyland Amusement Park, including what they believed to be an item known as Louie the Clown. Now, in order for the police to move forward and then for the county to proceed with criminal charges against Mr. Mays, on that same day, Roger Nelson was at the scene and himself verified that the clown that was taken out of Mr. May's house was in fact Louie the Clown, the one that was subject, that is the subject in this case. And also Jerry Ottaway, who had worked for the amusement park previously. And at trial, Mr. Nelson, who is the son of Margaret Spear, formerly Margaret Nelson, testified that he was present on that day. His job was to take a look at the item that was recovered and determine whether or not it was in fact the true item.
Mr. Whalen?
Yes, Judge.
Is it your contention then that as of the day that the police asked for him to identify Louie the Clown as the in fact original Louie the Clown, is it your contention that that is the day after that, therefore nothing after that date could be filed, that would constitute the waiver date? Is that your contention?
No, not that that was the exact waiver date, but under Kansas case law, in order to file for rescission, there has to be diligence in filing it. So it has to be filed within a reasonable amount of time.
Okay. And so what date would you think would be reasonable after that date? What is your specific date for no longer could rescission be requested?
Well, I don't know that the Kansas case law has ever said specifically what that date should be. But in the quote that I just read from Brown versus Wahlberg, the Kansas Supreme Court said, this isn't even guided by the statute of limitations. This must be done diligently. So what we have here is a difference in over 2 years from February of 2015 to October of 2017, when the unclean hands charge was then filed. So that would have been outside the statute of limitations for filing a fraud claim.
At the time that the police found Louie the Clown and Mr. Nelson said he believed that was Louie the Clown, did Mr. Mays admit that that was Louie the Clown?
I don't believe so, no.
So when do you contend that it was known for a fact in law that Louie the Clown was Louie the Clown?
On that date, he was positively identified by both of the experts that were later employed and presented testimony at trial. And so Roger Nelson is a family member who was involved with all of the contract and everything else that was involved in this matter.
So your contention is, as of that date in 2015, that is the date that it was known by law that that was in fact Louie the Clown?
Yes. Because if we look at the appellee's brief on page, I believe page 8, his argument is, well, we didn't know whether or not this was the real Louie the Clown until there was a criminal I guess it wasn't, it was the conviction date, the date of the plea, which was still in, I believe, September or mid 2016. So it was still another year and a half after, or 11 months, I apologize, 11 months after the entry of plea before the amended petition was filed. So even there, we still have almost a year. But
So your client was still denying the lie, but none of that matters. That's your argument?
yes, because in I believe it's Turner versus Jarboe, they specifically said, it was said that it is a familiar rule of law that a person who has been duped into making of a contract must act promptly and effectively in order to take advantage of his right to rescind. That once he is apprised of sufficient facts to put him on inquiry as to whether he was a victim of misrepresentation or fraud, which induced him to make the contract, he cannot let the matter drift, nor can he hesitate for long between two courses of action, one for rescission and another for damages.
Why don't you move on? You're rapidly running out of time. If there's another issue that you wanted to address, why don't you move on to that?
Very good. Thank you, Your Honor. Fraud must be pled with particularity. This has been repeated numerous times by the Kansas Supreme Court and this Court of Appeals. There was no fraud pled in the amended petition. And just saying we have facts and we are making this claim does not meet the strict adherence to the rule of filing a petition for fraud with particularity. In Vondrasek versus Midstate Co-op, a review of these assertions reveals that the Vondracheks have failed to sufficiently plead a fraud claim against Midstate. The petition makes no attempt to clearly delineate the 5 elements of fraud established by case law and set forth in Pick Civ 3rd 12740 for fraud. In neither petition were any elements of fraud listed or tied to the statement of facts from the original petition.
Mr. Whalen, could you tell me why fraud should be pled with particularity? Like the court's reasoning for that?
Probably not in the specifics that the court would, but I'll make an attempt. Because it is a specific act with specific states of mind that are involved, that in order to meet and defeat a summary judgment or motion to dismiss, that each of these elements must be shown within the original petition in order for the case to proceed and move forward.
Mr. Whalen, at trial, so let me ask it in this way. If the petition put your client on notice of the facts at issue for the misrepresentation claims that were then proven at trial, can you explain then how your client was harmed by the pleading?
This doesn't have anything to do necessarily with harm. This has to do with a requirement by the courts that this is how one is to proceed within a fraud claim. It's very specific and it's a very strict holding by the Kansas Supreme Court.
And do you have
there isn't a claim here of...
Sir, I'm sorry, Mr. Whalen.
I apologize.
Do you have a case involving rescission? Because it's not a claim for fraud. They haven't requested damages based on fraud. Is that correct? So it's a claim for rescission.
It is, but rescission based upon fraudulent misrepresentation.
I understand that. But in a fraud case, they would be claiming damages based on fraud.
Generally, that's correct. But
None are sought here. Do you have a case for us involving rescission based on misrepresentation and the pleading requirements for that? I'm curious because I've looked, and so I'm just wondering if you might have one.
Yes, actually, going back to Brown versus Wahlberg, They stated in Cleaves versus Thompson, 122 Can 43, it was held that where a party desires to rescind a contract on the ground of fraud and misrepresentations, he must, upon discovery of the facts at once within a reasonable time, announce his purpose. So they're talking about rescission based upon fraud and misrepresentation. And that is tied with, actually, that's the beginning of the quote that I just read to the court about the need to file within a diligent time. So the court has recognized fraud and misrepresentation and specifically talks about the application of misrepresentation in a matter of rescission.
Mr. Whalen, you've actually used your rebuttal time. I'm still going to give you 5 minutes of rebuttal, but you'll need to break now if you want to have that.
Very good. Unless there are any other questions, I will cede my time to to opposing counsel. Thank you, Your Honors.
All right, Mr. Kite, whenever you are ready.
Yeah, thank you, Judge. Appreciate it very much. Again, please accept my apologies for the video incapability this morning, but I don't think that will slow us down on what we need to visit about this morning. Let me do this again, since the court has read the briefs, and I appreciate that it's a hot court. Let me address the two areas that Mr. Whalen addressed in his opening remarks. First of all, the breach of contract was the original cause of action that was brought in the initial petition. That, of course, was filed back on February the 10th, 2016. Thereafter, on September the 19th, 2017, we filed an amended petition claiming rescission of the contract based on unclean hands, including fraud, misrepresentation, concealment, and illegality. As we said in our brief, I think the key element here is looking at the relationship between the original petition and the amended petition, and that takes us to KSA 60-215, amended and supplemental pleadings, and the requirements for doing those things. And I think the key is here, and frankly, Mr. Whalen hit the nail on the head when he said, talking about breach of contract and rescission of contract and filing a subsequent pleading, he said, it's not guided by the statute of limitations. Boy, that's correct. It's not guided by the statute of limitations. There isn't a time certain. A person should be diligent, but diligent in terms of what the facts are, what the circumstances are, those kinds of issues. So I believe in our brief, we set out very logically the fact that, contrary to Mr. Whalen's thoughts, when the automated animatronic figure, and I'm using those terms for a reason, was located at the home of the defendant on February the 17th, 2015, while potential experts on behalf of the plaintiff advised that this was, in fact, Louis the Clown, the defendant at that time and his wife, from that point forward and up to the first day of trial, continued to indicate that, in fact, this was not the original Louis the Clown, and it was only a replica. And so summary judgment motion after summary judgment motion was thwarted because there were genuine issues of material fact because of the denial of the fact that this wasn't the original unauthentic Louis the Clown, but only a replica. So we had information. It was the beginning of the story. It wasn't the end of the story. And so what the plaintiff did, in being as prudent as possible, was to go forward and a year later, on February the 10th, 2016, filed their initial petition within the 5-year statute of limitations for breach of contract. At the same time, ironically, the DA's office filed charges against the defendant for 2 counts of theft, including, among other things, Louis the Clown. Thereafter, a no-low plea was entered on October 21, 2016, of course, with the idea that both the defendant and his wife, Sherry Mays, continued to deny that it was the original and authentic Louis the Clown and continued to assert it was only replica. So this continues on and on, but for the fact that as of September the 19th, 2017, at the direction of Judge Hernandez Mitchell and within the time frame that she allotted, the plaintiff filed a second claim in a first amended petition. It was filed less than 1 year following the adjudication of the criminal case. Again, all in a timely fashion, because again, as Mr. Whalen pointed out, and I think this is key, these issues are not guided by the statute of limitations because, in fact, the statute of limitations for the initial petition had been met. The defendant had been placed on notice. There was nothing surprising about the events and circumstances that followed thereafter.
Counsel,
In fact,
can you explain to the court why you believe that the almost year delay between the plea and the rescission amendment to the petition is timely?
Yes, Your Honor, there was a number of summary judgment motions and other things that were going on in the interim. Those had to do with taking out of the case the issue of the authenticity and originality of Louis the Clown. So during this period of time, there were a number of pleadings and arguments and hearings that were held to address those issues. Unfortunately, because of the denial by the defendant and his wife that, in fact, this wasn't the original Louis the Clown and it was only a replica, this persisted and delayed the situation to a point that it was determined we've got to go forward at this point. We can't prove the fraud, but we can certainly plead the fraud. There's quite a difference between the two, but we certainly felt and believe today that the amended petition that was filed included with specificity all of the elements of fraud that were necessary to be pled.
The rescission claim remained in the pretrial order that governed the trial. Is that correct? Am I correct on that?
Absolutely. That was the foremost claim. Absolutely. Let me go forward a little bit more, and that is simply this. I'm not sure what my time is, but with respect to being pled with particularity, we went to the extent of simply including almost the entire amended petition. We pulled out those specific paragraphs that addressed the 5 elements of fraud, and we inserted those and brought those to the court's attention and highlighted those in the subsequent argument following our layout of the first amended petition just for the court's review, so that you could see, in fact, very clearly that fraud had been pled with particularity. And of course, what we did in the brief is we followed that same approach, and in providing the witnesses at trial, we provided those witnesses in a specific way to address each and every one of the 5 elements of fraud so that those were not only pled in the pleadings, but proven at trial. And obviously, Judge Hernandez Mitchell was convinced that, in fact, following the trial, those various elements of fraud had been pled. And I think the interesting note is that every instance of fraud is also an instance of misrepresentation. However, not all forms of misrepresentation are acts of fraud. And as the defense pointed out, there are 2 forms of misrepresentation. One is fraudulent misrepresentation, and the other one is negligent misrepresentation. By any review of the facts, the circumstances, the evidence, and the testimony at trial, this was certainly not a case of negligent misrepresentation. It was a clear case of fraudulent misrepresentation, which was recognized by Judge Hernandez Mitchell, who did an admirable job in weighing and balancing all the facts and evidence, addressing issues that came up with respect to experts. She handled those matters quite expeditiously, and quite candidly, she did a fine job in managing that trial. So to the extent I haven't covered everything that the court is questioning, I'd be very glad to address any questions that the court might have.
Apparently there are none, Mr. Kite. Thank you very much for your argument.
Thank you, Judge. Appreciate it very much. Again, I apologize for no video connection, just an unstable internet connection.
That's quite all right. Mr. Whalen, you still have your 5 minutes of rebuttal.
Thank you, Your Honor. I just want to clarify something. I never said that the statute of limitations does not apply. The requirements for filing a rescission action are governed by diligence, not necessarily by the statute of limitations. That's what the Kansas Supreme Court said, that you must act on it in a quick manner or you waive. And here, once you ratify the contract, which they did in their original pleadings, you can't then come back and say, oh, well, now we're going to go for a misrepresentation, unclean hands fraud. That initial ratification of the contract by filing an action to enforce the contract prevented them from going forward with any sort of fraud or misrepresentation claim. And
So
that's what the case law.
Mr. Whalen, it's your contention then that by initially filing the petition for one claim and then amending to add another, that initial petition satisfied total ratification of the contract?
Yes.
So in no case may you file a petition and amend it to add an equity claim.
Well, I think it's good. Well, what the court has said is once you are aware of the potential for fraud, you need to file that for fraud, because if you do anything else to ratify the contract, you are prevented then from later filing a fraud claim. And that's specifically what the case law says. And in this case, the basis for the prosecution in the criminal case against Mr. Mays was based upon the expert finding of Roger Nelson and Jerry Ottaway that the Louis the Clown that was discovered was the original. So that was the date of notice to at least say, whoa, we may have a cause for rescission here. And that was still a year before they filed their original petition, or I guess probably 8 months to be more accurate. So they had the knowledge to at least further investigate or take some sort of action, but instead they went ahead and filed a motion, a petition, in order to enforce the contract, thereby with knowledge of potential fraud. Because fraud is not established by the filing of or the conclusion of a criminal matter, because in that case, there would be no time limitation on fraud claims until somebody was caught, prosecuted, and found by plea or by trial to have committed an illegal act. That is not where fraud comes from. Fraud comes from the misrepresentation, or, in this case, the fact that Mr. Mays had the actual Louis the Clown in his possession. And it was identified as the original by 2 separate individuals, including a family member of Miss Spears. So that is what prevents them from filing the claim later on. A year before they filed their motion to enforce the contract, they at least had knowledge that the original clown was found at Mr. Mays' home. That's where the problem comes in.
So the plaintiffs didn't vigorously investigate your client's lies. Is that where you're going with this?
No, there was no further investigation really that needed to be done, Your Honor. They were on the scene of Mr. Mays' house.
But Mr. Mays was contending that was not the correct Louis the Clown, that was not the real Louis the Clown.
I don't think that matters when you have a family member of Miss Spear and a separate expert stating for the state and the police that this was the original. They knew it was the original. Mr. Mays' claims against fraud are immaterial because it's when they had notice.
Mr. Whalen, that would have still been a factual dispute in the trial, though. you still made that a factual dispute in the trial.
Well, it was still, quote unquote, a factual dispute in this trial. And the same two experts who made the finding for the state of Kansas testified on behalf of Miss Spear. The exact same two people testified, Jerry Ottaway and Roger Nelson, that this was the original Louis the Clown that they saw on February 17th, 2015. Same evidence that they had on February 17th, 2015.
You've got about a minute.
Your Honors, I thank you. I believe that the case law, quite honestly, is very clear as it relates to the filing of a rescission claim having to be timely, and that it can be waived by any ratification of the contract once knowledge of potential fraud is made. And unless the court has anything else, I thank you very much for your time today and appreciate appearing before this court.
Apparently, there's no more questions. So counsel, thank you both very much for your briefs and your arguments. We will take the case under advisement, get a written decision out to you and your clients just as soon as we can. Thank you.